All right. We are on the record in the matter of the people of the state of Michigan versus Ben William Palmer. That's two files. The first is 23-41472-ST-3. The second is 24-43004-FY-3. I'll take the appearance of counsel, please.
Larry Brown on behalf of Mr. Palmer.
All right. There are two cases in front of me right now. One is looks like a. Make sure I got them right. The Attorney General's case is
the 24 case. The other one is fines and costs, and the action sheet indicates what the fines and costs are when they were assessed and what was paid.
Okay. The first case, the 24 case, is being prosecuted by the Attorney General's office. They've made a bond and pretrial release recommendation, and I'll get to that in just a minute. The charges in that case are 3 child support failed to pay charges. Count 1 is from July 1st of 2018 through June 30th of 2019. Count 2 is November 1st of 2019 through January 31st of 2020. And then also October 1st of 2020 through February 28th of 21. And then count 3 involves the time period of May 1st of 21 through May 31st of 2024. They indicate that those happened within the city of Gaylord, Otsego County, and the charges read as follows. Count 1 did not pay support for his child in the amount of and at the time stated in an order entered by the Otsego County Circuit Court in file number 2011-014102-DP. That's a felony offense, has a maximum penalty of 4 years and or $2,000 fine. Each of the subsequent 2 offenses read exactly the same, other than it looks like they read exactly the same case number, just different time periods that I read previously, and they each also have a 4-year and or $2,000 maximum penalty. Mr. Palmer, do you understand the allegations made against you?
Yes, Your Honor.
Do you understand the maximum possible penalty in each case?
Yes, Your Honor.
All right, there are certain rights that I want to advise you of. You have the right to have an attorney, and I'm going to address that in just a minute with Mr. Brown. We'll decide whether or not you need a court-appointed attorney or want to retain your own for today's purposes. You also have certain trial rights that I want to detail for you. If you wanted to have a trial on this, you would have the right to have a trial by a judge or by a jury. You'd have the right to be presumed innocent until proven guilty. You'd have the right to have the prosecutor prove that case beyond a reasonable doubt and have that burden of proof be on him at all times. You'd have the right to have witnesses appear for your defense, and the right to have a subpoena, a court order for those witnesses to appear and testify for you. You'd right to have the right to see, hear, and question all the witnesses against you. You'd have the right to be a witness yourself or to remain silent. And if you chose to remain silent, that silence could not be used against you because you have an absolute right against self-incrimination. Do you have any questions about any of those rights?
No, Your Honor.
As to an attorney, how do you wish to proceed? Do you want to have a court-appointed attorney, or do you want to have time to retain your own, or do you want to proceed today on your own?
Probably a court-appointed.
All right, Mr. Brown, have you had contact with Mr. Ward?
I have, Your Honor. I have, Your Honor. He will qualify, and that information has been sent to Mr. Gila's office for appointment.
All right. So, Mr. Palmer, there's an attorney in town who helps the court out with actually appointing each of the specific court-appointed attorneys. So I'm going to grant your request for court-appointed attorney, and Mr. Gilo will send you information and contact information about the specific attorney that's going to represent you in this particular case. And because of that, I'm going to enter not guilty pleas on your behalf as to each of the 3 counts. So that will preserve your rights and not take advantage of anything that we shouldn't do ahead of time. The Attorney General's office has made a written bond and pretrial release recommendation, so I'm going to read that to you, Mr. Brown, so you have that knowledge of that information. Their bond recommendation is that he owes $21,589.61, and that the minimum requirement for that is 25% of that under state statute, which is MCL 750.165, subparagraph 3, not less than 500 or up to 25% of the arrearages, whichever is greater is their request. They are not requesting any no contact provisions or any domestic violence issues. I think that's the rest, the long and the short of that. So, Mr. Brown, any comments that you wish to make as to bond?
No, Your Honor. I did speak with Mr. Palmer. I did advise him that there would be probably a 25% minimum bond here because that is statute. And because it is statutory, I really don't think there's anything we can do about it. But I would ask the court to accept the statutory minimum.
And I will do that. That's going to be cash only because that is part of the statute as well. Little different than the bond amendments that they've done recently otherwise, but all right, let me make sure we've got anything else. Is there anything else we need to do today that you know of, Mr. Brown?
Not that I can think of, Your Honor.
All right, that cash amount, if my math is correct, is $5,397. And that would be cash. I'm going to write cash only.
Excuse me, Your Honor.
The general rules of the court, as far as making sure that Mr. Palmer, if he does post bond, appears for any court requirements, that he not leave the state without permission of the court, not commit any crimes while released, immediately notify the court of any address or telephone number changes, not use alcohol or illegal controlled substances, and then contact community corrections within 24 hours of release and follow through with all program requirements. Those will be in place as well. Do you have any questions, Mr. Palmer?
There's no possible way I could like put my car up for collateral or anything so I'll make it to court?
I wish that there was something else I could do, but the statute is very specific. It's 25% of the amount. So I've given you the minimum that I can do. You can discuss that in further detail with the court-appointed counsel, but I'm confident that they'll probably give you the same response. There is one other file that you have with us. That's the 23-41472-ST-3, in which there are fines and costs owed of $438, and that was assessed on March 6th of 2023 and has never been paid. So there's a bench warrant out for your arrest on this file as well. This was originally a no license charge, so I think you probably only got fines and costs on that to begin with. Mr. Brown, how do your client wish to proceed as to this?
Your Honor, I mean, he's going to be sitting there for a while, is my guess, based upon the bond amount in this particular matter. If Mr. Palmer wants to speak to me further, I can do that. But based upon his other case, I believe he may just enter a plea to that today.
Mr. Palmer, you've heard Mr. Brown speak, and I want to make sure that I hear from you on that as well. You are charged with failing to comply with the court order to pay what is still due, $438 in fines and costs on your underlying charge of operating with no license or multiple licenses back in January of 23. You were sentenced to pay that amount in March of 23. Do you want to have an attorney appointed for you on this case as well, or do you want to enter a plea today as to that?
I'll just enter a plea today.
All right. You have certain rights on a bench warrant on a probation violation, which include the right to have a trial that would be by a judge and not by a jury. You have the right to subpoena people to appear on your behalf. You'd have the right to see, hear, and question witnesses against you. You'd have the right to have the probation department prove the case by preponderance of the evidence. If you enter a plea today, all of those rights would be waived or would be given up. Do you understand that?
Yes, Your Honor.
Do you wish to proceed today without a specific attorney appointed to you? Mr. Brown is here assisting you today, but he hasn't necessarily been appointed for the future. Are you satisfied with that level of assistance, or do you want to have a court-appointed attorney assist you further?
This is fine, Your Honor.
All right. Has anybody promised you anything or threatened you in any way to get you to enter a plea today?
No, Your Honor.
All right. Would you raise your right hand, please? You solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor. I do.
All right, you can put your hand down. I've just recently given you your advice of rights. Do you fully understand those advice of rights?
Yes, Your Honor.
And you've told us that you don't want to have any additional attorney other than Mr. Brown with you today. Does that still remain true?
Yes, Your Honor.
And you've also told me that you wish to proceed today and that no one has promised you anything or threatened you in any way. Does that also remain true?
Yes, Your Honor.
Is it also true that you were sentenced back in March of 23 on the charge of operating no license or multiple licenses?
Yes, Your Honor.
And that was from this district court, the Otsego County District Court. Is that correct?
Yes, Your Honor.
And were you sentenced to pay fines and costs in the amount of $438?
Yes, Your Honor.
And is it true that you failed to make any payments as to that?
Yes, Your Honor.
All right, I'm going to find that you've given me a proper factual basis and that your plea was knowingly and intelligently and voluntarily given to me. All right, I'm going to simply sentence you to pay the $438. You're already in jail on the other case as well. You're probably going to remain there for a while. I know you have a huge requirement through the Attorney General's office. When do you think that you can pay this $438?
It's probably within a week or so after I get out.
Do you have employment?
Not at the moment, just odd jobs.
How long have you been in jail now?
Since last night.
You can do even more. I mean, we don't like to wage crime victim in the state fees, which is high, but we can move it out for a few months and monitor it that way. You can do even more.
Okay. Mr. Palmer, given the amount of money that you owe in child support, I have no faith in your ability to make any payments in this particular case. And court staff tells me that I'm not supposed to waive the crime victims' rights fee and the, I think there's one other standard court fee.
State fee.
The state fee, which is $75 and $50 or $125. But you owe literally 100 or probably 1,000 times that in your child support already. So I'm simply going to give you credit for 2 days, sentence you to 2 days jail. I'll give you credit for 2 days jail and waive the fines and costs. Simply because there's no way that you're ever going to pay that. And it's not worth anybody else's time to monitor that.
Thank you, Your Honor. I'm sorry.
Well, I'm sorry too, but you've got a huge debt over your head and you need to make payments on that. So I'm going to get rid of the smaller problem for you today. All right, that'll be all. Thank you.
Thank you.
Your Honor, just to double check, you don't have anybody else today?
No.
I don't. No, we don't. Thank you very much for asking.
Have a good day.